And welcome everyone again to the celebration of 40 years of the Journal of Law and Religion. My name is Silas Allard, and I am the managing editor of the Journal of Law and Religion. It has been my pleasure to serve as managing editor for the last quarter of the journal's 40 years since the editorial home of JLR moved to the Center for the Study of Law and Religion at Emory University in 2013. It is a wonderful opportunity for me to see many old friends on this Zoom call today, and also to see and meet many members of this community that I haven't had the chance to before. So again, I really appreciate you all being here. In the summer of 1983, the Journal of Law and Religion published its first issue. Wilson Yates and Michael Scherschlicht, I think Michael is with us this morning. The journal's inaugural editors opened their first editorial with these words, quote, "In undertaking this venture, we seek to provide a forum, a place to hear and be heard for all those interested in exploring how law and religion are related." And this has been the mission and mandate of JLR for 4 decades. The charge from Wilson and Michael was embraced by Marie Falinger and Patrick Keifert when they took over the reins of the journal in 1989, writing in their first editorial, quote, "We take up the challenge which Michael and Wilson left us, to encourage the widest possible diversity of thoughtful, well-written views about law and religion, to inquire deeply and persistently into the relationship between these disciplines and these practices, and to ask courageously the common questions which they raise," end quote. When the Center for the Study of Law and Religion assumed editorial leadership of the journal in 2013, the new co-editors pledged to continue, quote, "highlighting the breadth and depth of the field, as well as the many important questions that require continued scholarly attention, by making the Journal of Law and Religion a repository of the important voices on these issues." And in December 2020, which in an editorial in that issue, which closed the 35th volume of the journal, the then 5 co-editors welcomed 11 new colleagues from around the world and across religious traditions and scholarly disciplines by invoking that first line from Wilson and Michael. "We seek to provide a forum, a place to hear and be heard for all those interested in exploring how law and religion are related." It is this commitment that has made the Journal of Law and Religion not only a publication, but a community of scholars for 40 years. We gather today to celebrate the legacy of leadership in law and religion represented by 40 years of articles, essays, reviews, and symposia, but we also gather to celebrate this community and the next 40 years of excellence. So thank you all for joining us today, for sharing in this celebration. And I am delighted to turn it over to our first set of presenters, Tom Porter and Marie Falinger. Tom Porter is a trial lawyer, mediator, teacher, and minister. He was a founding partner of the trial firm of Mellick and Porter, LLP, in 1983, and has been a trial lawyer since 1974, representing universities, hospitals, professionals, religious institutions, nonprofit organizations, and others. Tom has been working as a mediator since 1996. He was a lecturer at Boston University School of Theology from 2005 to 2019, where he founded and directed a program in religion and conflict transformation. He was also the executive director of Just Peace, Center for Mediation and Conflict Transformation in the United Methodist Church from 2000 to 2012. He's the editor of the book, Conflict and Communion, Reconciliation and Restorative Justice at Christ's Table, the author of The Spirit and Art of Conflict Transformation, Creating a Culture of Just Peace, and co-author of The Journey, Forgiveness, Restorative Justice, and Reconciliation. Tom was a founding member of the board of the Journal of Law and Religion in 1982 and was chair of the board from 1989 through 2001. He was also founder and president of the Council of Religion and Law from 1978 to 1985, which was instrumental in the creation of the journal. Professor Marie Falinger holds the Judge Edward J. Devitt Professorship at Mitchell Hamline School of Law and served as interim dean of Hamline University School of Law prior to its combination with William Mitchell College of Law. Prior to her teaching career, Marie spent time in public interest lawyering in the Legal Service Organization of Indiana, prologuing a long career of profound service. Marie is the editor of several important books in the field of law and religion, including Feminism, Law and Religion, On Secular Governance, Lutheran Perspectives on Contemporary Legal Issues, and Lutheran Theology and Secular Law, the Work of the Modern State, along with dozens of book chapters and articles in the field. She is the recipient of numerous awards, including the degree of Doctor of Law, honoris causa by Valparaiso University in 2014, Minnesota Lawyer Attorney of the Year Award, the Minnesota Women Lawyers Award, the Minnesota Women Lawyers Myra Bradwell Award, the Wesley Faculty Award, the Minnesota Justice Foundation Law School Professor Award, and the Journal of Law and Religion Achievement Award. Marie served a long and vital tenure as editor-in-chief of the Journal of Law and Religion from 1989 to 2013. Tom and Marie, I'd like to hand the floor over to you. Tom, you're still muted.
I'm muted. That does. I just would thank you, Silas, for getting us all together here. This is wonderful. What a joy to see so many dear friends this morning. Researching and remembering this brought back so many wonderful memories. The story of the founding of the Journal of Law and Religion begins with Emory's own Frank Alexander, whom I'm looking at right here. While a student at Harvard Divinity School and Harvard Law School in April of 1976, he led the effort to set up a committee on religion and law. A group of law professors such as Harold Berman and theologians such as James Luther Adams and practitioners as well. The first event of the committee was held at Harvard Law School, March 5th through 6th, 1977, and was entitled A Symposium on Theology and Law, Responsibilities of Vocation. The presentations included a seminal article by the Dean Roger Crampton of Cornell Law School on the ordinary religion of the law school classroom. The second day of the conference was an intensive dialogue around what was being done and what needed to be done by those interested in the interrelationships of law and religion. Professor Morton Horwitz commented, "I think this was the most moving and deepening time I've spent in the 10 to 12 years that I've been associated with Harvard Law School." On March 24th, the committee, with the encouragement of the symposium participants, decided to expand its vision, to incorporate, to develop a board of directors, and to change the name to the Council on Religion and Law Choral. The first board meeting was on November 19, 1977 at Harvard Divinity School. I will list the members of that board when we publish the article. The list does not tell the story. In my experience, I was in the presence of greatness. Just to describe a few, Harold Berman gave us the map in his book, The Interaction of Law and Religion. James Luther Adams and Harold taught a course together, and Wilson Yates, who became the general editor of the journal, was in that first class. Jim Adams could tell a story that had more wisdom than a series of lectures. Pauli Murray was a civil rights lawyer and the first African-American woman Episcopal priest. There is now Pauli Murray College at Yale University. William Stringfellow, after leaving Harvard Law School, went to East Harlem to practice law, and Karl Barth described him as the greatest theologian in America. Doug Sturm, Professor Bucknell, wrote more than I think anyone on the relationship between law and religion with great clarity and with passion. Judge Lois Forer brought her experience as the judge in the Court of Common Pleas in Philadelphia to our gatherings. Ed Gaffney, later the Dean of Valparaiso Law School, always reminded us by his words and actions of the prophetic role of both Law and Religion, and later Virginia Mackey, who was the mother of the restorative justice movement, joined the board. And we should note Mark Taylor, who was a student at Harvard Divinity School at the time, and later a lawyer, was the coordinator of all of our activities and was key to our success. Coral was very active with a large national membership and many events and projects, including major symposium. We had a booklet entitled Interface, which was describing existing programs, courses, and associations, people working to promote the interrelationships of law and religion, encouragement of a wide range of new courses and programs of various institutions, an extensive bibliography of literature, and a newsletter to keep us connected. From the beginning, we had primarily two goals. The first goal was to establish an institute for law and religion, and Doug Sturm headed up that effort, but it was Frank Alexander who accomplished it when he moved in 1982 from his law practice to being a faculty member at Emory Law School with the establishment of the Center for the Study of Law and Religion. And Frank encouraged his friend and professor Harold Berman to join him, and he did so in 1985. The second was to establish a journal of law and religion. Now, we boldly announced in the Coral newsletter in the summer of 1980 that we would publish such a journal in the late fall of 1981. The issue would include the articles from a symposium that was held at Harvard Law School, which we were co-sponsoring in September of 1981, on religion, law, and the political process. John Corrigan was named editor-in-chief. John occupied the law office right next door to me in our law firm. John was a brilliant lawyer. He was he had a great love for religion, trained as a Jesuit. But it became apparent very quickly that you couldn't practice law and edit and publish a journal, and we failed at this endeavor. But we were fortunately rescued by Steve Young, who's here with us this morning, the dean of Hamlin Law School. He came to the rescue. In the fall of 1981, he began conversations with Harold Berman, his teacher at Harvard, about developing a program in law and religion. Steve invited Hal to meet with his faculty and to also meet with the president of Hamlin at the time, Charles Graham. In Steve's words, he wanted Hal to present his vision of the foundational importance of religion for informing jurisprudence and envisioning law as an arm of social justice. And Hal then reported on these conversations at the annual meeting of Coral on December 5th, 1981. He noted how impressed he was with the faculty, including Howard Vogel, who's here today, a Quaker, and Michael Scherslig, a Lutheran, as well as Coral's regional coordinator in the Minneapolis area, Wilson Yates, professor and dean of United Theological Seminary of the Twin Cities. I represented Coral in the conversations with Hamlin, including discussing the possibility of co-sponsoring the Journal of Law and Religion, all with the enthusiastic support of John Corrigan. Harold and I visited Hamlin, and the collaboration with the journal was affirmed, and we brought with us the papers from that symposium. The first meeting of the board of editors of the journal was held on November 6, 1982. Doug Sturm, Ed Gaffney, and I represented Coral. Robin Lovin, who was a professor at the University of Chicago Divinity School, Michael Scherslig and Wilson Yates represented Hamlin, with Dean Young supporting all our efforts. Michael and Wilson became the general editors. Ed became the book review editor. Howard agreed to do an in-depth study of recent literature, and through the years has always brought depth and wisdom to the life of the journal. Doug was elected chair of the board, serving until 1988, and he played a critical role in guiding the development of the journal. Hal gave a significant financial gift to the new venture, and Marie will go on to describe other people who joined the board, remarkable people later on. We also elected an advisory committee, and I will list those when we do the published articles. So 40 years ago, in the summer of 1983, Volume 1, Number 1, as Silas said, of the Journal of Law and Religion was published. In the editor's preface, Michael and Wilson wrote, and I'm going to repeat it again, Silas, because it's important. In undertaking this venture, we seek to provide a forum, a place to hear and be heard for all those interested in exploring how law and religion are related. They go on to say, we will publish works that cover a diverse range of issues and subjects regarding the relationship of law and religion, including historical studies, articles that deal with theoretical questions of jurisprudence and theology, essays on the meaning of such concepts of justice and rights, power and authority, works focused on the interaction of clergy and lawyers, and studies regarding the interplay of law and religion in the social arena. The Journal of Law and Religion from the beginning was an interfaith, interdisciplinary, peer-reviewed journal that came out twice a year. And I'm going to offer just a very brief glimpse at the richness of the initial work from 1983 through 1988. Under Gaffney's leadership, the book reviews were always a significant part of each issue. The articles illustrated the understanding that the intersection of law and religion takes place on numerous planes, historical, theoretical, and practical, and not simply in regard to any particular issue. The only exception to this was the second issue in 1987 on South African liberation, introduced by Charles Villavicencio from the religion department at the University of Cape Town, South Africa. His article was entitled Theology, Law, and State Illegitimacy, an Agenda for Theologians and Lawyers. Robin Lovin was the guest editor of Volume 2, 1984. Robin focused on issues concerning religion and law in the American political sphere, drawing on the University of Chicago project on religion and the American public life. This issue also contained a discussion between Joseph Cardinal Bernardin, Martin Marty, and Judge Arlen Adams on the public role of the religious leader. The journal was always interested in hearing from religious leaders and religious institutions about how they were dealing with issues of law. Volume 3, 1985, included papers from a colloquium on law, metaphor, and theology at the Washington Lee University Law School. The colloquium focused on and responded to a paper by Milner Ball, professor of law at the University of Georgia School of Law, where he argued that the metaphor of law as a bulwark of freedom was inadequate and suggested an alternative metaphor of the law as a medium of human solidarity. Ed Gaffney was the guest editor for Volume 5, 1986. The issue focused on the papers delivered at Loyola Law School at a colloquium on law and religion in the first-year curriculum of the law school, Contracts Towards Property Procedure. This issue also included a new feature of an annual survey of trends and development in religious liberty, in the courts. Carl Esbeck did this in 1985, and he did it for other years after that. Volume 6, 1988 marked the end of Wilson Yates' role as general editor because of increased demands on his now role as president of United Theological Seminary. Michael Schursig said Wilson has thoroughly understood the spirit and intent of the journal. Accordingly, he has been a thoughtful and careful editor, a knowledgeable and wise evaluator of manuscripts, and a sensible counselor on administrative matters. The same would be said about Michael, who continued as general editor for one more year. In 1988, as Silas said, Marie Falinger became an assistant editor and then general editor of the journal. Brilliant, wise, spiritually and intellectually profound, with wit and humility. Marie, as Emily Hartigan said in her tribute to Marie in the 2022 issue of the journal, Marie was at several levels the journal until it moved to Emory. The members of the board of the journal became more than an academic community. We always began each of our annual meetings by sharing our stories of our journeys from the last meeting. For me, this community of scholars and practitioners understood that religion and law are both about right relations and justice as solidarity or love. And they lived these understandings. And for me, this community has become family for me, and you and this community continue to enrich my life.
Thanks, Tom. And I will, like Tom, given the time, I'm going to offer some brushstrokes of the people and work that characterize the journal during its second phase from 1988 to its move to Emory in 2013. As the journal moved into its second life after Steve Young, Wilson Yates, and finally Michael Scherschlick left, it retained the interdisciplinary, interfaith, peer-reviewed format Tom spoke of, while expanding its hospitality to ever more faith traditions, subject matters, and international readers. We began with 3 editors, as you heard: Lutheran theologian Pat Kiefert, theologically trained law professor Howard Vogel, and me, with somewhat fuzzy assignments as we apprenticed to Mike Scherschlick for volume 6, and then pretty much took over ourselves with volume 7, honoring the work of Robert Cover. Eventually, we specialized, as you heard, and I became editor-in-chief. The production and business end of the journal, including word processing, subscriptions, dealing with our printer and authors and budgets, originally rested with the Hamlin Law Faculty's secretaries, Gail Schroer, Mary Diedrich, then Joanne Madsen, and others. But ultimately, it became almost a full-time job for Linda Berglund, our last production manager. I need to especially to acknowledge the work of my Hamlin colleague and hot friend, Howard Vogel, later with some help from our legal writing instructors, Mary Dunwald and Steve Lebo. They spent hours and hours teaching law students technical aspects of verifying the very complex citations from all times in all places in the world and fixing technical flaws. Howard also did the drudgery of supervising financial aspects and legal filings of the journal. And of course, we had great book review editors like Ed Gaffney, Leslie Griffin, Christy Green, who's here, Perry Dane, who's here, Mike Steve Smith, and Howard Vogel, who's here as well. Journal 2.0 was decidedly a shoestring operation. Other than Linda, all of us were producing the journal as a volunteer overload to our day jobs. Many of my decisions about manuscripts and editing work happened at my kids' athletic practices or in the playground. And for my colleagues, it was somewhat the same. The modest price of $15 for two-issue volume for individuals and $25 for institutions for many of these years did not even cover our printing costs most years. So Howard and Linda had to negotiate with Hamlin's administrative deans to cover our cost overruns at year's end. To its credit, Hamlin, a small, unknown, and terribly underendowed university with eternally tight budgets, routinely covered our deficits in its Methodist generosity and as a demonstration of its pride that an international journal had its home at Hamlin. We even decided to create a nonprofit so we could do some fundraising to supplement the endowment Harold Berman left. But unfortunately, we had little time and fewer prospects for fundraising, giving the journal's primarily academic readership. The vision of the journal never wavered over the years, though, even as members of the editorial board came and went. The crisis of the West that had produced the necessity of founding a journal where law and religion communities once again could speak to each other gained academic recognition over the years. The journal, as one of the few consistent voices in this field, was joined by numerous law and religion scholars writing in both specialty and mainstream law reviews. Conferences and organizations for those interested in that dialogue proliferated, and both elite and non-elite law schools added specialists in the field of law and religion to their faculties. Bucknell theologian, as you heard Doug Sturm, who kept us grounded in that vision, ultimately referred to 6 characteristics of the journal's work, some of which Tom mentioned: the historical, the theoretical, the ethical, the global, the professional, and the spiritual, which Emily Hartigan was instrumental in focusing on as well. I encourage you to read his description in our statement of perspective, which we published in every issue back then. It's true that at yearly journal board meetings, we did our work evaluating content, planning issue themes, assessing budget and organization, but that was not all. For the journal board was made up of, shall we say, brilliant and courageous thinkers who, for the most part, defied the conventional wisdom of their disciplines and communities. Our board presidents over these years included Doug, Tom Porter, and St. Mary's Law Professor Beto Juarez, from very different backgrounds, but very common commitments. We had passionate Catholics exploring the spiritual mystery of the law, like St. Mary's Emily Hartigan, and the cruelty of totalitarianism, like Valpodine Ed Gaffney. We had careful, reflective Jews like Hamlin religion professor Earl Schwartz, who's here, and Rutgers law professor Perry Dane, who's also here, who brought whole intellectual words out of the single texts. We were graced with clear-eyed and honest Protestants with profound commitments to ethical reflection on social justice, like Emory's Frank Alexander, McAllister theologian Paula Cooey, Medgar Evers theologian Darrell Trimew, Georgetown law professor Anthony Cook, and SUNY Buffalo's Betty Mensch. Some of our board members devoted themselves to thinking about the meaning of a life in the law, like Tom, Fordham law professors Amy Allman and Russ Pierce, and Tennessee attorney and judge Nancy Miller-Heron. Others made important contributions to the role of religious arguments and ethics in public life, like Emory's Michael Perry, SMU theologian Robin Lovin, Notre Dame's Kathy Caveney, and University of Toronto's Anver Eamon. We had wonderful feminist Muslim challengers to modern secular and religious orthodoxies, like Richmond law professor Aziz Al-Hibri, itinerant theologian Amina Wadud, Wisconsin law professor Asifa Qureshi, and Syrian Canadian intellectual Afra Jalabi. We had Colorado's Deborah Cantrell, our Buddhist, who always brought us back to self-reflection. Hawaii's Kath Sands, who contributed a humanities perspective, and even our most religious of agnostics, Penn's Howard Lesnick. Occasionally, we'd also consult with our prestigious advisory committee, whose traditions and interests spanned the globe. As Thomas said, this was truly a community, a place where we could reflect on our professional and personal journeys over the years and how we saw the wider society evolving. Some moments we won't forget. Doug Sturm leading us in songs from the Union movement. Our board members, Amina Wadud, castigated for arranging women-led Muslim prayers, and Zev Falk, the faithfully challenging Orthodox Jewish rabbi and lawyer, both leading us in prayer. In the midst of post-9/11 anti-Muslim sentiment in the United States, Aziza Al-Hibri asking us if we would stand with Muslims and taking us to Friday prayers at a local mosque. Frank Alexander, inspiring us with the saints who had gone before, like Bill Stringfellow and Harold Berman. The Hamlin Law and Religion Symposium, which came out of those meetings, that broadened the circle to include many others, lawyers, theologians, activists, teachers, as well as academics, those who were interested in that year's law and religion theme. We created the Journal of Law and Religion Achievement Award to recognize the courage of those who dared to dream about a new way for law and religion to work together. At the JLR Awards dinner, we recognized some of the giants in our field. Among others, American law and religion icons Tom Schaefer and Milner Ball and Ed Gaffney, as well as Barbara Aldave, working to mold the Latinx Catholic Law School at St. Mary's. Abdullahi Naim, who conjoined religious piety and religious freedom, and Howard Zehr, the father of the restorative justice movement in the United States. We also embarked on major projects and themes over this year. There was the Williamsburg Charter issue, curated by Ed Gaffney, which brought a host of well-known political and academic voices to rethinking the place of religious freedom in American life. There was our first double issue devoted to Islamic jurisprudence, put together by Aziz Al-Hibri, gratis copies which were sent to many corners of the globe thanks to a Lilly Endowment grant. Its goal to help both Muslims and non-Muslims understand the force and complexity of Islamic jurisprudence. Jawdat Saeed, a Syrian dissident and intellectual whom we honored with an award, contributed a stunning article on the Islamic vision for peace and justice. We hosted an issue largely devoted to cataloging the emerging field of restorative justice, inspired by the work of the South African Truth and Reconciliation Commission, including once again Charles Villavicencio, who contributed his essay, The Reek of Cruelty. There were symposia and published issues focusing on emerging Islamic scholars, Lutheran theology and law, assisted suicide, American religious liberty history, and what it means to be a person of faith and a lawyer. And that's just to name a few. There was a revised table by Carl Esbeck of Supreme Court religious liberty cases, and a book review issues picking up some of the missed great law and religion books of the 2010s, again with Ed Gaffney at the helm. As my time is up, I will just close with the words of Doug Sturm, who captured the human paradox with which our journal community in these years concerned itself and its commitment to responding to that complexity. He wrote, "Perhaps more than we can ever fully discern, our lives are but expressions, albeit creative expressions, of the communal matrix that sustains us, inspires us, and constitutes the origin of our dreams and yearnings, our obligations and our rights. We are members of each other. We belong together. That is the source of our joy in life, although that is as well the source of the tragedies of life, the dark side of our history that all on too many occasions makes us shudder." I did not mean this initial comment, please understand, as sheer sentimentality. It is instead both a political affirmation and a religious declaration, and it provides an opening for further reflection on a vision of justice as solidarity. Howard Vogel said more simply what this communal experience with the journal meant to many of us. My work and my association with all involved in bringing to life and keeping the JLR going taught me that justice is a form of love. Thank you.
Thank you, both Tom and Marie, for those wonderful reflections on the very rich history of the Journal of Law and Religion. And it is my pleasure at this time to introduce Perry Dane, who is going to reflect on the vision and impact of JLR. Perry Dane is professor of law at Rutgers Law School, where he has taught since 1992. Before coming to Rutgers, Perry taught at Yale Law School and clerked for both Judge David Bazelon of the U.S. Court of Appeals and Justice William Brennan of the U.S. Supreme Court. Among his dozens of publications, Perry has written landmark articles on choice of law, religion and law, the jurisprudence of Jewish law, legal pluralism, and jurisdiction. Perry has served in several distinguished visiting professorships and fellowships, including at the University of Toronto Faculty of Law, the University of Western Ontario Faculty of Law, Rutgers Center for the Critical Analysis of Contemporary Culture, and the Tikva Center for Law and Jewish Civilization at the New York University Law School. In 2011, he received the law school's inaugural Dean's Award for Scholarly Excellence at Rutgers. Perry served on the JLR editorial board from 2010 to 2013, currently serves on the International Advisory Board, and has served as a book review editor for JLR in the past. Perry, the floor is yours.
Thank you so much, Silas, and thank you, Tom and Marie. That was stunning. I'm delighted to be here to help celebrate the 40th anniversary of the Journal of Law and Religion, though I feel like an imposter, more than I usually do even. I was not present at the creation or for many years later, though I did come on board eventually. But I do want to try to put at all in time. In fall of 1984.
Perry?
Yes.
We lost you there for a second. So if you don't mind backing up to, I would like to put, and going forward from there.
So I'd like to put the creation and the mission of the journal in some perspective. As I said, I was not present at the creation, but I have my own story at about the same time. In fall of 1984, my colleague at the Yale Law School, Burke Marshall of blessed memory, and I began to teach a course on religion and law. The best part, of course, was meeting with Burke in his office for an hour before every class, hammering out what we wanted to talk about. I remember how new that course on religion and law seemed. It was by most standards a conventional course, much more conventional than the Journal of Law and Religion, which we've heard described and which I'm going to talk about more in a few minutes. Our course focused on the free exercise and establishment clauses of the First Amendment, with a few sub-constitutional topics thrown in. But even that sort of straightforward doctrinal religion and law course seemed innovative. The typical so-called First Amendment course focused on freedom of speech, press, and association with barely a nod, if that, to religion. There were no law and religion casebooks then. We compiled our own materials. The reason that our course was unusual, the reason that the Journal of Law and Religion was transformational, had a lot to do with the profoundly secular background assumptions of elite academic culture, especially during the broadly defined middle years of the 20th century. As I experienced the law school as a student, as a faculty member, and for that matter, much of Yale at the time, the place was not anti-religious as such. This was long before the rise of the new atheists. And to be sure, it had a divinity school. The old Protestant hymns figured centrally at academic ceremonies. The chaplains were political firebrands. And some of us were religiously engaged in our various personal ways. But all that seemed peripheral, and to be truthful, often still does, to the academic community and its culture. The reality, again, was not so much hostile to religion, but indifferent. How that happened, how the old colonial colleges, Congregationalist Harvard and Yale, Presbyterian Princeton, for that matter, Dutch Reformed Rutgers, as I often remind my colleagues, evolved, how those institutions evolved into determinately secular institutions, is a story that real historians have told in great detail. But I can report that the secularity was not just institutional, it was cultural and personal. And the secularity was, again, and this bears emphasis, not so much a matter of belief or lack of it, but just lack of concern, lack of consciousness. So the change symbolized in a little tiny way by the course that Burke and I co-taught, and in a much more significant way by the beginning of the Journal of Law and Religion, that change was significant. And it was part of a larger challenge to this background secularity of academic culture. Something was afoot. It was apparent in the creation of CSLR. It was apparent in law schools in other ways. In my own experience, the earth shook with the work of Robert Cover, whose Nomos and Narrative dates to around the same time. Others will point to different scholars at the center of their attention, many of them involved with the journal. But the renewed interest in religion was obvious in other fields too. Analytic philosophy, for example, which once deemed religious language not false, but just meaningless. Analytic philosophy saw Alvin Plantinga come along, among others, with his account of warranted religious belief. So now we are apparently, with that beginning, in the fourth generation of analytic philosophy of religion. The old stalwarts would have been shocked. That period, or thereabouts, give or take some years or even some decades, that period also saw a further burst of serious theological thinking that was not insular, that confronted modernity directly and persuasively, from Stanley Hauerwas to Rabbi Joseph Soloveitchik. A distinguished philosopher with whom I chatted in the Yale Law School faculty lounge one day told me that he was reading Soloveitchik's Halachic Man, but could only do so in small doses, lest he be hooked. And that's one thing he didn't want. So what explains the increased academic interest in religion? Again, this is a much larger story than I can tell here. Part of the answer might be that this was the same general era as when the old simple secularization thesis, the notion of a sort of singular trend line of religious decline, when that thesis fell out of fashion. Religion was not dying. In some places, it was resurging. Significantly, though, this new academic interest in religion and its respectability in the United States and elsewhere has continued and grown even as Western religion itself finally does seem to be, at least by the statistics, to be in decline. We're in the era of the so-called nuns, N-O-N-E-S, I love that pun, and the spiritual but not religious. So what gives? Part of the answer is that we now see secularization itself as a much more complex process. The most compelling account of secularization in our age is not the simple model of simple linear decline, but the world historic, complex, multifaceted, paradoxical picture that Charles Taylor has so brilliantly drawn for us. Moreover, even something like the phenomena of the spiritual but not religious is sociologically and religiously fascinating beyond any simple trend line. The intellectual challenge is to decide how it fits into the larger stories of religion, modernity, atomization, polarization, the decline of all manner of collective institutional and settled identities, not to mention our current political state. When I attended my last Yale College reunion a few years ago, students actually seemed more religiously engaged than when I was there in school, but they were engaged as seekers. We're living in interesting times, and the Journal of Law and Religion is both an explorer of that story and part of the story itself. So let's get back to the journal. Because as I suggested, what was remarkable about the journal was not merely that it began publishing at a time that situates it as part of that larger reimagination of the academic encounter with religion. That would be interesting. But what we should really mark and celebrate, and which Tom and Marie talked about, is the journal's mission, vision, and ambition, which trace back to its own prehistory and continue in its new form under the auspices of the Emory Center. So I said that the course that Brooke Marshall and I taught was mainly doctrinal, and US constitutional doctrinal for that matter. But the Journal of Law and Religion always had a much broader agenda. It examined an entire panoply of issues: the secular law regarding religion, religious views of secular law and of the state, political philosophy, political theology, religious law in its own right, legal pluralism as an idea. To see this at work, just consider, again, some of the topics of some of the articles in the very first volume of the journal. Religious Foundations of Law in the West by Harold Berman, of course. Public Morality in Law, the Social Ethics of Brandeis. Biblical Religion in American Politics. The Evangelical Rediscovery of Law and Politics. Well, we've seen how that has turned out. Jewish Perspectives on the role of religion in the political process, and Catholic Perspectives on Morality and the Law, and so on. As well as the legal authority of the Buddha over Buddhist orders of monks. We should pause to note just how remarkable this was. We take it for granted, but we need to really think about how remarkable this was and continues to be. Do we see anything analogous in any other journal devoted to law and its relationship to some facet of our common life? Would a journal of law and business have this sort of scope? Or a journal of law and art, or law and sports? For that matter, do we see that sort of ambition even in most other forums devoted to religion and law? Not enough. And to the extent that they do, it's very much under the influence of the Journal of Law and Religion. Though it seems to me, at least, that something like this breadth of vision and diversity of genres and approaches should be built into any coherent effort to examine law and religion. The point here, though, is not just the breadth of interests or the variety of topics. What's at stake here is not just intellectual curiosity. The founders and editors of the journal were convinced that this kaleidoscope of law, religion, morality, politics, each taking stock of itself and of the others, that this kaleidoscope was essential to reconstituting a healthy polity. Consider some other words from the editor's preface to the first issue of the journal. In most societies, the editors wrote, the institution of law and religion share a great deal. Both lay claim to authority, both rely heavily on tradition, both surround their processes with solemn ritual, both involve their practitioners in the application of authoritative texts, usually couched in specialized languages. Both are viewed by their societies in which they exist as central to the creation and sustenance of a just, peaceful, and orderly community. In a time of cultural crisis, the institution, and I'm still quoting, the institutions of law and religion often collide. Both are challenged to re-examine their fundamental assumptions. It is in the light of this challenge that scholars and practitioners in both fields have begun to turn to each other in the hope that a better understanding of how they're related and how they interact will contribute to the resolution of that crisis and the greater realization of the common good. Even more evocatively, consider the remarkable statement of essence of the original Council on Religion and Law that Tom spoke about. The authors of that statement described a period of crisis in law and values. The roots of that crisis, they wrote, are found in the collapse of the values which form the foundations of law and characterize its authority, as well as in the death of God theology and its juxtaposition against death of law jurisprudence. In other words, law and religion was suffering through a common challenge, even in a nation dedicated to their institutional separation. The authors called for, among other things, a systematic inquiry into the fundamental values of our laws and the source of authority of those values. In other words, all these topics, law's account of religion, religion's account of law, each of their accounts of itself, the exploration of morality, were part of a larger meta-topic to which the journal was committed. All this makes sense to me, though my own angle of approach is slightly different. I've always imagined secular law and religion engaged in an encounter with each other, trying to make sense of each other, each trying to overcome the solipsism to which every normative system is otherwise susceptible. The encounter is intercommunal, it is juridical, it is also ethical. Those various topics belong together because they reflect each other. They can speak to each other, even as they speak from their own distinct worldview. We can't fully appreciate that encounter unless we actually study each voice in its own terms. There's another part to this that Tom and Marie hinted at, and which in its early couple of issues was most marked by that article whose title I mentioned, The Legal Authority of the Buddha over the Buddhist Order of Monks. Increasingly, the Journal of Law and Religion, and certainly continuing in its current incarnation, has sought to consider questions in other countries and in the full range of world religions, including non-Western religions. It is genuinely international and multi-faith. But again, though, this is not just intellectual breadth for its own sake. This is not just a matter of expanding the canon, as one might do in a literature class. Comparisons are how we stretch our minds and our souls. But more to the point, the larger story of law and religion should be a story of particularities. It's the only way it makes sense. It's not the law writ large with a capital L, or religion writ large, but legal systems in all of their richness and detail, and religions in all of their detail. So the larger story is about how the encounter of law and religion, through its particularities, helps establish a counter-narrative to the simple pieties of modernity. So I want to end by suggesting a pair of paradoxes. Secular modernity has often been accused of relativism. That charge doesn't entirely stick, and the very idea of relativism verges on being incoherent. But be that as it may, there is a paradox, and the paradox is that even as secular modernity, if not relativistic, at least gestures towards relativism, it is at the same time inspired by a certain ascetic monism. At a conference sponsored by the journal a few years ago, I quoted John Rawls, not the Rawls of his great philosophical works, but the Rawls who meditated on his remaining religious convictions. Rawls, in an essay not meant for publication, gave us a remarkable clue to the deeper convictions of his theory of overlapping consensus, his famous theory of overlapping consensus. So here's Rawls. Rawls said, we need to consider how the relation between God's reason and moral and political views may be conceived. God's reason, he wrote, is different from ours in that its powers far surpass ours. Yet God's reason is the same as ours, including that of atheists, in that it recognizes the same inferences as valid, the same facts as true, that we recognize as valid and true. Beyond that, we may suppose that God's reason is consistent with ours. So far as we can comprehend the case, God's idea of reasonableness and ours yield the same judgment. So the problem with Rawls' statement of faith is clear. It's not his overestimation of human reason, but it's rather the sort of failure to appreciate that different religious traditions do, in fact, in profound ways, understand God, morality, and the world distinctly. Their answers are different, and so are their questions. To imagine that religious and moral reason can, at the end of the day, only take one form is to live in flatland. The Journal of Law and Religion, then and now, by inviting a multiplicity of values, international and interfaith, religious and secular, religio, legal, philosophical, theological, is moving beyond flatland. It's constructing a three-dimensional constellation of normative worlds. But of course, religious traditions embody a very similar paradox. On the one hand, they tend to assert the reality of truth with a capital T. On the other hand, one of their greatest challenges, and they're all conscious of this, but one of their greatest challenges is to overcome that pull of solipsism, to give the state its due, right, which is how you get religious views of the law and of the state, and to find dignity in other faith traditions. So inviting voices from all those traditions, describing those traditions, publishing them together, is not just intellectually vital, it's a gift to the traditions themselves, and it's a gift to us all. So happy anniversary.
Thank you, Perry. Thank you for those wonderful reflections and for putting on display the erudition for which you are well known and admired in this community. Our final presentation comes from Jaclyn L, who will be meditating with us on the future of the journal. Jaclyn L is Associate Professor of Law and Director of the Center for Asian Legal Studies at the National University of Singapore. She is editor or co-editor of multiple volumes, including The Constitutional Interpretation in Singapore, Theory and Practice, Pluralist Constitutions in Southeast Asia, Regulating Religion in Asia, Norms, Modes, and Challenges, Constitutional Challenges in Singapore, Reforming the Singapore Elected Presidency, and Religious Offenses in Common Law Asia, Colonial Legacies, Constitutional Rights, and Contemporary Practice. She has also edited numerous journal symposia and special issues in law and religion, comparative law, international law, and Asian law, which is not to mention her numerous book chapters and articles on these topics. Jaclyn has held visiting positions at Frankfurt University, University of Munster, University of Trento, Melbourne Law School, the Max Planck Institute for the Study of Religious and Ethnic Diversity, and Princeton School of Public Policy and International Affairs. And she has won numerous awards, including the Asian Yearbook of International Law's DILA International Law Prize and the SHAPE SEA Research Award. Jaclyn currently sits on the editorial board of the Asian Journal of Comparative Law, the International Journal of Constitutional Law blog, the Journal of Constitutional Research, and Suprema, a Journal of Constitutional Studies. the latter two being Portuguese language journals, the Portuguese titles of which I cannot pronounce with any integrity. She joined JLR as a co-editor in 2020. And I want to say a special word of thanks to Jaclyn, not only because it is now tomorrow in Singapore, where she is presenting from, but that she agreed to present third in today's event, and that she agreed to take on the most challenging presentation, which is to think about the things that are to come for the journal. So with that, thank you, Jaclyn, and the floor is yours.
Thank you, Silas. Good morning, good afternoon, and good evening to all of you. First, congratulations to the Journal of Law and Religion on 40 years of publication. It has been a real privilege for me to hear the storied history of this journal and to hear reflections on its impact. I wanted to also thank Silas and Whitney for this invitation and for organizing this. Truly, I am both honored and humbled to be asked to provide reflections on the future of the Journal of Law and Religion today. If, Perry, you felt any hesitancy, imagine mine, especially as I see so many esteemed scholars here whose works I have studied, admired, and quoted in my writings. There are truly many more well-qualified co-editors among us, and they would also have important things to say about the future of the journal, I'm sure, which we will hear from them later on in the discussion, I hope. But I will now embrace my identity, as Silas puts it in his email invitation to me, as a, quote, a relatively new member of the editorial board, and as someone who is thinking hard about the globalization of law and religion as a field. So with tribute and respect to all my fellow co-editors, past and present, allow me to offer some thoughts on where we could direct our attention towards the future of an internationalized global journal of law and religion. Well, after all, I am speaking to you from the future here in Singapore, as Silas pointed out. It is now Saturday, 29th April on my side. Now, we call ourselves simply the Journal of Law and Religion, JLR, affectionately. But these three words, law, religion, and encompass so much breadth and depth and height. And some of this we've already heard in the previous presentations. I mean, what is law? What is religion? What is law and religion? And of course, we make things harder for ourselves by promising and committing to publish cutting-edge, interdisciplinary, interreligious, and international research on law and religion. So in thinking about today's remarks, I thought, what would make this journal, what would the future of a global JLR look like? And the central theme to my remarks today are more plurality, more pluralization. And of course, there are many pathways for pluralization. We will not have time for all of that, and I'm sure there are many sort of different ideas for pluralization. But today I will just focus on three main areas in moving towards this global journal of law and religion. Simply put, more religions, more laws, and more ends, or more law ends religion. So going on my first, more religions. There is a big persistent definitional puzzle about what is religion. The answer often also depends on the discipline. Within law and religion, we know that this question has also taken on a constitutional flavor, where courts grapple with the question of what is religion, what practices fall within the scope of constitutional protection, and create different constitutional tests to determine this question. Within sort of the trends that we see in law and religion, or constitutional law and religion, there have been shifts from a more theistic form of religion into more pluralistic ideas of religion. The history of the journal in some ways reflects this initial strong emphasis on Christianity and more established religion, but this is also shifting. We've seen that the content in the journal on Islam, for instance, has increased over the years, especially after 9/11. And despite this emphasis on Christianity, initial emphasis on Christianity, we note that JLR has never closed its doors to other religions. And as Perry already noted, the journal published its first article on Buddhism very early on in its very second issue. But the content that we have still requires will need to greater reflect the global complexion of religion. This would require sort of greater emphasis on non-monotheistic religions, for instance, Hinduism, Taoism, animist religions, atheism, and agnosticism. And this is the kind of content that we do increasingly see in the journal, but in pluralizing these different categories of religion, this also requires us to re-examine how conceptual categories that have been developed under a more Judeo-Christian frame may need to be rethought. We may need to re-examine some of these conceptual categories so as not to reproduce incongruent understandings and problematic constitutional and legal outcomes. Now, a Judeo-Christian framework that emphasizes textual authority, voluntary inner faith, and individual rights might not fit in well with certain types of religious traditions that do not have these similar traits. We see this critique among some scholars who examine, for instance, how Hinduism in India has been constructed, recreated, and modernized to fit into a sort of colonial Judeo-Christian-based categories of religion. Scholars also emphasize how this dissonance reproduces forms of power, inequalities that could result in contradictory forms of freedom and control. Furthermore, some of false equivalences may be drawn between these different religious traditions as phenomenon of the same kind, thus resulting in an overemphasis on certain forms of conflicts that typically are reproduced and reflected in monotheistic religions. So sectarian rivalry, truth doctrines, conflicts over truth doctrines, conflict over proselytization and conversion tend to be overemphasized if we employ these categories of religion. So we need a plurality of categories and theories to better capture the range of religious traditions, and this itself requires a fundamental challenge to the way in which we think about religion. In addition, I would also want to emphasize another sort of form of pluralization in thinking through religion, and this is the pluralization that arises in a technologically changed world. Digitalization of religion is happening. What effect would this have on religion? What effect would it have on law? And what would law and digital religion look like? COVID-19, as everyone knows, has accelerated the use of technology and social media. And this includes the use of technology and social media to spread and consume religious content. I've experienced this in my personal life. I spend way too much time on my devices. Today, we don't just do emails, text, and online shopping, or receive sort of religious newsletters, devotionals, and so on our devices, through emails and so on. We also can follow the Pope on Twitter. We can follow, one can follow your favorite imam or mufti on Facebook, or even follow your church, mosque, temple on Instagram. The total number of people around the world using the internet has increased exponentially, about 64.6%, according to the data on Data Reportal. 64.6% of the world's total population is today connected online. And this will only keep increasing, right? So part of this online usage also involves religion. What are we understanding from this rise in internet usage? What kind of potential is there to change religion? Because now digitalization of religion means that religion could also exist, at least partially independently, if not entirely, from any offline forms. Heidi Campbell, for instance, defines digital religion as the technological and cultural space that is evoked when we talk about how online and offline religious spheres have become blended or integrated. This blurring of the line between online religiosity and offline religiosity may continue and may have a radical impact on the way we think about religion. And on social media, this interconnectivity is only going to be accelerated. Social media could enhance and amplify previously marginalized religious voices. At the same time, digitalization challenges traditional structures of authority within existing religions. So today, anyone can be a social influencer of religion. You do not have to be connected or related to any offline religious authority, offline religious organization. This means that social influences of religion can give voice to alternative viewpoints, but they are not subject to any constraints associated with existing religious structures, for better or for worse. In addition, religious influence can be hinged upon the ability to create content that can go viral. So rather than content that is necessarily right or good. So digitalization also can change how religious organizations deliver content, reach their adherents, receive feedback from their adherents, collect donations, so on and so forth. It also can transform religious organizations' decision-making processes. We can use big data and analytical tools to refine religious content and activities in order to appeal to the broadest range of constituents, right? So there is, for instance, an app called, which is Glue's Insights Plus, which allows churches to aggregate data and analyze them in order to understand community strengths and opportunities, to figure out what kind of content to provide to its followers. Now, if you think back, if we take a step back, what does this mean for religion? What is religion? Because is religion merely about responding to consumer preferences, or is there a quality to religion that seeks to lead in shaping morality? And in addition, should law respond to some of these digital changes? Because at the end of the day, digitalization of religion could bring some negative impact. For instance, the amplification of religious disagreement and conflict. And we have seen, for instance, the internet, the online spaces serving as sites of interreligious conflicts that could escalate to physical offline violence. On an even deeper level, thinking through the impact of technology on religion also require us to consider whether there are certain existing assumptions about public-private divide in the field of law and religion that needs to be rethought and re-examined, because religious apps and social media, when you put up content online, it subverts the private nature of the assumed private nature of certain religious practices. So with these sort of technological changes, the future of the JLR would also require us to start thinking about technology and religion. So secondly, more laws, or rather more sites of laws. Now, in the May 2022 editorial that I wrote for the journal titled Law and Religion, Asia as Critical Ground for Rethinking Existing Frameworks and Dominant Paradigms, I noted the projected reshuffling of the religious profile of the world. Now, this is based on a report that I'm sure many of you are aware of, the Pew Research Center's The Future of World Religions, Population Growth Projections 2010 to 2015. Now, it projects that Europe and North America, which were previously the center of Christendom, are likely to become less religious by 2050. These are projections. We can take it with a pinch of salt. But if you take these changes, these shifts seriously, then we also have to seriously consider what a global JLR would look like. A global JLR that would have to engage with a much greater range of the world, and to take that range of the world seriously, that geographical range of the world seriously, because the shifts in religiosity will require us to seriously engage with these regions. We already do that, and and I'll come to that. But just sort of thinking through the numbers, we see, for instance, that Asia Pacific is the main region projected to have a significant increase in the proportion of religiously affiliated persons. So with these projections, this means that we need to pluralize the sites of study for law. With these changing religious demographies, shifting centers of religiosities provide us with opportunities for new areas for the study of law and religion. as we shift our gaze towards these regions beyond the conventional geographical areas that JLR has tended to sort of focus on, again, this has been changing. This also means that the philosophical foundations of law and religion scholarship would also have to be rethought. I did a very quick search, very, very unsophisticated sort of data search on the journal's website. And, material that sort of centers or addresses issues in America feature in about half of our articles there. Again, this is changing, and we do see, for instance, more articles and symposiums centering other regions and other laws. On Asia alone, a major jurisdiction has gotten increased attention is Indonesia, and rightly so, right? It is the country with the largest Muslim population in the world. Content on China, unsurprisingly, has also increased greatly, we do see this pluralized content published more in the second half of the journal's existence. So we're on a trajectory, a good trajectory, I would say. And so in the editorial I mentioned, I focus on Asia as a key incubator for new areas of studies on law and religion. But of course, this is not just limited to Asia, right? Other regions, including Africa, grapples with issues concerning law and religion that would require localized innovations that could further illuminate our scholarly and policy understandings of the field. So lastly, more law and religion more sort of theories and philosophical sort of conceptualization of law and religion. Because by expanding our religious and geographical lenses, we should also be invited to pluralize our dominant theoretical frameworks. This means that rather than bringing dominant frameworks built upon experiences in particular settings, we might want to rethink and consider how we could see these new sites as opportunities for theory building. So this means that it is a global view of law and religion. It should not just be about finding new sites for theory testing or theory application, but as sites for theory creation. So we've seen, for instance, how law religion scholarship has, typically create a lot of the law and religion scholarship that we publish has sort of centered ideas of secularism, separationism, and neutrality. But does this really reflect the reality and concerns of law and religion in a great many parts of the world? In some ways, not. In fact, in many regions and jurisdictions, it is the entanglement of religion with the state that is the norm rather than the exception. Empirical studies also show this. Professor Jonathan Fox, for instance, has a study that shows that the separation of state and religion is the exception rather than the norm. And the one country that has scored high on the separation index that he used is the United States. Allow me to share this anecdote. I recall a conversation with the late Justice Scalia during his visit to Singapore, sadly shortly before his passing. At the time, I was working with colleagues on a research project on regulating religion. Incidentally, the book Regulating Religion in Asia, which Silas mentioned, was reviewed in the journal, so thank you for that. But after sort of hearing me describe about the regulation of religion, the sort of different modes of regulation and so on, Justice Scalia looked at me, and he had this look, as many of you might know, which I suppose can be described as bemused, and said, regulating religion, that sounds so foreign to our Western ears. And I thought that was fascinating because it assumes that Western states do not regulate religion, but they do, directly or indirectly. Indirectly, I mean, there are many general laws and regulations that have impact on religions and religious behavior and religious organizations. There are many laws that there are certain laws are more direct in terms of regulating and management of religion, but they are by no means the only form of regulation. And so what also seems really interesting is that the idea that the state could be entangled with religion was seen as, ipso facto illegitimate. But this might not be the case in most South jurisdictions, even in many European contexts, right? They are just seen as this part of the state's embedded and ongoing negotiated relationship with religion. And so perhaps by recognizing an entanglement framework as a starting point rather than separationism, we could surface many more ways in which religion engages the state beyond the usual, though important, constitutional claims, which are premised on equality and freedom of religion. So to regard entanglement as a reality is, in fact, the way many scholars in many other jurisdictions see their scholarship. They are not just novel exceptions. They are part of the diagnosis of society. And to understand that is to allow for a more informed critique of law and religious practice and vice versa. So in conclusion, JLR has always seen field of fields building as part of its mission. And the words of the first editor's preface of the journal by Professors Michael Sheshlik and Wilson Yates in 1983 remains very relevant today. As they noted how the journal sought to fill a gap given rise by a growing interest among practitioners and scholars on the intersection between law and religion, and the need for a forum for these conversations to happen. They wrote, in a time of cultural crisis, I quote, in a time of cultural crisis, the institutions of law and religion often collide as they seek to discover what they are in relationship to that crisis and to each other. Both are challenged to re-examine their fundamental assumptions. And indeed, challenging fundamental assumptions is part of what we do here at the journal. It has been a transformative platform. It has been a great resource for me in my scholarship. And so as we support even more scholarly engagement, with the aim of pluralization and accepting even the displacement of dominant frames and paradigms, we will be able to move even closer to a global journal of law and religions. So more laws, more religions, and more sides of ends. Thank you.
Thank you so much, Jaclyn, for those reflections and for those challenges as we think about what the future of the journal needs to be and how we make it what it can be. And I am deeply grateful that you are my colleague, our colleague in that endeavor. So thank you again. Thank you to all of our presenters for such rich presentations and for keeping pretty close to the time limits that I encouraged them to. So we have a good 35 minutes for conversation. As I mentioned at the beginning, we'll use the raise hand feature. You can find it in the reactions at the bottom of the screen, and that'll help us create a queue to take folks' questions or comments. I imagine that lots of people have contributions to make, so I'll just say, if you can package your comments or questions into a relatively brief format so that we have plenty of space and time to hear from lots of folks. Christy Green, I see, is at the head of the queue. So Christy, the floor is yours.
Yeah, so I'm going to attempt to make a sort of integrative expression of thanks to all of our speakers today. I can say that with Perry, I'm a relatively recent vintage of the journal. I've been on board since 2010. And I actually came to my study law and religion from the field of Russian studies, which has great resonance, Silas and I know, with a current project that we're doing at the Journal of Law and Religion, which started in November 2021 as a symposium on law, religion, and the state in Russia. And then a few months later, when Russia invaded Ukraine, took on all sorts of different nuances. But one of the things that we're actually dealing with right now is the sort of variety of responses that Russian scholars in particular have had to what's going on. Some of them are ardent human rights advocates and, are concerned to do what they can to challenge the Russian state. Others have had, we think perhaps have had the more difficult response of basically capitulating to Putin, and in one case, spouting pro-Putin propaganda online, which is something that we're dealing with. But it makes me think of what Marie said about the sort of tragedies of life that law and religion deal with, of what Perry said about things being linear, but perhaps sometimes unlinear. And what Jaclyn said about the important role of law and religion in the formation of our character, and sometimes in the hands of an authoritarian state, the deformation of character. So I guess even as we look forward, I am feeling blasted backward now into these older concerns, which are all of a sudden new again, but of inestimable importance for law and religion, and a testament to the power of those fields, both to shape us and control us, which I hope we'll continue to pursue in the Journal of Law and Religion.
Thank you, Christy. Emily Hartigan.
Yeah, I just wanted to, I wanted to note we've been joined by Ed Gaffney. Hey, Ed. He was not here at the beginning, and he does remind me of something I was really interested in Jaclyn's forward-looking critique, invitation, because of course we couldn't get, there was the Hindu guy in the Minneapolis-St. Paul area that you could invite, the one guy, you couldn't get him very often. That is, the resources for a global dialogue are growing globally. And so we did, because it was Minneapolis-St. Paul, we could get Chief Justice Yazzie of the Navajo Nation for the restorative justice stuff, but who was available, who was circulating in the conversations? And Ed reminds me of the fact that we used to have wonderful fights over, shall we say, diversity. And my experience of the journal was that of all of the areas in the legal academy that had perhaps one of the most creative and liveliest conversations seeking to expand our particularities, the journal was it.
Thank you, Emily. Yeah, Michael. Go ahead and unmute yourself, Michael.
About to do that.
We got you. Go ahead.
You got, well, I'm British. I do not think very often, having been retired for almost 15 years, and I don't think in the same way about these matters as I once did. But I do recall, well, first of all, it's so good to see people that I knew well and that I still think about and that I wish well for. I mean, Marie and Howard and Tom Porter, I mean, I could go on and on. These were relationships, professional and quasi-personal, that were and still are important to me. And they emphasized the community that we had across boundaries and not seeing each other often, but still triggered by the same impulse. There's something to these disciplines, these organizations, these ways of human expression that engage us in this double way. Obligations and the nature of law and the way we conduct ourselves in accordance with law, and the way we each have a different manifestation of what we'd call religion, and the way they combine and the way they interact is so important. And when we started this, pretty well ignored. You could get articles all over the place on church and state and on First Amendment rights in the United States, but you couldn't get down beneath that to what it is about the human need and development of people with black robes, people where they do things in silence, people where everyone lines up in rows and pays attention, entities where there are books that everyone treats as a little special. These things are obviously related for human beings, and why weren't we thinking about these things? So when Steve Young came and said there's a group called Coral, and there's a course at Harvard with James Luther Adams and Howard Berman, and he gave me this little book, The Interaction of Law and Religion, which to me, if I had to list all the books, I mean, my favorite book in the world is Moby Dick, so I guess but anyway, besides, and the Bible. But the book that really, as a law teacher, I thought this is a direction that I would like to be part of going in that direction. And so to take those papers and sort through them and decide on the cover color, and Wilson and I kind of saying which one of these and how and who wants to look at what. And we were not experienced editors, and we certainly weren't experienced developers of publication, but we just did it. And one of the only thing I'd like to leave as I look back and reminisce, don't be afraid to do something that's sort of unusual, but that seizes you and that you know there's something there. Go ahead, even if it's kind of unusual and not maybe respected by everybody. Not everybody at Hamlin Law School thought this was a good idea, but we did it, and I'm grateful. And when I look at what others have done, Marie is a wonder. Howard is a wonder. These are people I knew and I appreciate, and they did so well. Well, I'll be quiet. Thank you very much for doing this, and for all the people that carried forward the Journal of Law and Religion. I thank you.
Thank you, Michael. Michael and I spoke briefly by telephone yesterday. And one of the things that he mentioned was when the Journal of Law and Religion was founded in the early 80s, the only other journal you could identify in this area was the Journal of Church and State, which was publishing largely in the area of doctrinal work on First Amendment related questions. And I think one of the testaments to the legacy of JLR is that if you were to pick up a copy of the Journal of Church and State today, it would look a lot more like the Journal of Law and Religion did in its early years. The expansive notion of law and religion that was created by the work of JLR has spread beyond its covers to other societies, other journals, other publications, which I think is a real testament to the work that so many people have done to create and shepherd this journal over the years. Yes, Whitney.
Thanks, Silas. I'm trying to find the hand button and I can't seem to, but thank you. I just wanted to say, so my name is Whitney Barth. I'm the still relatively new executive director of the Center for the Study of Law and Religion. And I just wanted to say how amazing it is to hear from all of you and to get to relive or to live, many of us for the first time, this history about the journal. It's such a rich resource and that we're so proud of here at the center. And I just want to say my heartfelt thanks to everyone who has given, everyone who has given so much over the years to the journal and to make it thrive, and to everyone who continues to give your time and effort and expertise to make the journal what it is today. And Jaclyn, your thoughts about the future were just so wonderful and rich and have given me a lot to think about already. So I'm just really grateful to everyone. And I just wanted to express that to all of you. So thank you so much.
Yeah, Ed.
Well, as several of you have noted, Harold's book was a very, I mean, the lectures at Boston University did call to public attention the connections that are the third part of Jaclyn's thing, law and religion. It's the conjunction. But I think Harold was able to do that primarily because he was he was so deeply interested in history and what had taken place over a very, very long chunk of time. And it isn't just a 20th century discovery that law influences religion and that religion influences law. He said those things so succinctly and so well that you couldn't deny it anymore. But he grounded it in that kind of historical tenacity that called the attainment of those insights revolutionary, and did so in 3 volumes, each of which was a big chunk of looking at the ancient world or the modern period after the Middle Ages, and then looking at the Russian Revolution, because he was such a wonderful scholar in Russian history and culture. So I think we have a longer pedigree, so to speak, that goes back across time, maybe not to the Big Bang, but with lots of imperial errors, lots of enmeshment and taking over religious ideas and turning them into totalitarianism and murdering people by the millions. Sometimes there are secular historians who look at the history of warfare and point a finger as they might at religions for inciting envy, hatred, contempt, and the things that underlie warfare. But I think a more honest appraisal of the history of war, because one of the things that I did was international law that governs the use of force, and that led me, as a good student of Harold Berman, into lots and lots of historical examples that point out that the Führers and the Duces and the imperators that do atrocious things with no check or no restraint or no second guess, no time for reflection, just what the king wants to do. In fact, that very simple point of who has the power to declare a war is handled very differently. Let's say in the Celtic archipelago, where the British king could send his troops to Ireland for centuries, because he's informed by his chancellor, Thomas More, that he can't be an emperor. Henry VIII was concerned about, why are these people on the continent calling themselves emperor? And I'm not an emperor. He said, well, Majesty, you can't be an emperor unless you're a king of more than one country. And so Henry VIII resolved that very swiftly by sending the troops to Ireland. That kind of way of thinking is, of course, somewhat restrained in our American culture because of its repugnance for monarchy. And we don't have one. And it's always fascinating to me, there's so much American curiosity about the royal family, other than the social injustice of giving it such vast sums of money to carry on with their ludicrous lifestyle. And the Windsors are perhaps the most hilarious example of that. But our constitutional commitment is to vest that decision of whether to go to war in the people and in the people's representatives in the House of Representatives. It's not given to a king who could do such arbitrary things as Hitler's declaration on the 6th anniversary of his coming to power by saying that the goal preventing war, as if he wanted to prevent war when he was speaking on January the 30th, 1939, getting ready to do exactly that, going to war, by blaming the Jews and by saying that if these Jews with their bankers are going to start another war, well, that the result will be not the triumph of the Bolsheviks and the Jews, but the annihilation. The German word is Vernichtung, the annihilation of the Jewish race in Europe. It's true, many priests, many bishops were collaborators. That's disgracefully true, and that's part of our job as law and religion people, to see that the religious institutions themselves can fail to carry out the prophetic work of resistance. But the resistance to state is just as important a part of religion, at least as I understand it, in the broad sense in which Harold used that term, as any other way of thinking about how calamity has occurred over time. Cultural enrichment, well, one of the funny things about the lovely underscripts and CC, the hidden captions that we've been gifted with in this conversation, is the constant inability of the software to differentiate between secularization and sexualization. They always hear the word comes in the conversation, and bam, we're being sent down a different path. But the errors of religion with respect to personal dignity and the capacity and role of women's society, the list is long of all the mistakes that religious communities are not immune from. On the other hand, the most lovely part, I think, of the last presentation by Jaclyn is that we just have to keep constantly focused on the always changing modalities of the conjunction and give full respect for the modalities that Perry talked about of the particularities of why is a Jew and why can't they be honored and respected as Jews? Why do we Christians have an enterprise to convert them to become like us, Jews who are basically committed to a rabbi from a remote province that had very little influence in the law of Judaism at the time, a sort of a marginal Jew, as one of the finest studies of Jesus by my dear friend who just died about his work. Jesus was a marginal Jew, not the one that we were gifted with once Constantine got the bishops together to define him in dogmatic terms. This kind of work is open-ended and it's never going to stop, I hope, very soon, because then we will be talking about the need to get back to the Big Bang and become more modest about what any of us in this tiny little blue dot in the pluriverse has to contribute to civilization. I'm grateful for all of you, and I want to say long live not the king, not Chuckles or any other king. Long live the Journal of Law and Religion. Thanks so much.
Thank you, Ed. Wonderful reflections. Christy?
Yes, thank you, Ed. And speaking of ands, I wanted to take the liberty to mention another and here, which is that the Center for the Study of Law and Religion now houses two law and religion publications. The Journal of Law and Religion has a sister publication online, Canopy Forum Interactions in Law and Religion, which is a digital journal. And I actually see that we have Rachel Emerita, who is one of our very talented Emory students who handles solicitations for our journal. We've got solicitations for essays on different topics running all the time, and people submitting individual essays. We've got one up at the top of the reading list right now on religion in schools and state legislatures. Rachel sent out a solicitation for essays on law and religion in Central America and the Caribbean. So we've got pieces coming in from Nicaragua, Cuba. We've published more than 500 essays. We recently hit 500, and we have a very important conference coming up next Wednesday, May 3rd. In fact, we've got two contributors, I think here, Whitney Bart and Professor Angela Carmela are both contributors. So I would invite Rachel maybe to let the audience know about when that's happening on Wednesday and how to access. But the topic is religion, law, property, and the crisis in houses of worship. So who would like to say more about that?
Rachel, do you have those details on hand?
Hi, everyone. Yes, I can share a registration link in the chat for everyone. But yes, our virtual conference will take place next Wednesday, May 3rd, from 11 to 1 p.m. Our participants, yes, Christy is a co-host. Then we'll see Dr. Barth and Dr. Carmela there, who, Dr. Carmela, I've only interacted with you via email, so it's nice to put Zoom face to behind those. But yes, this has been such a wonderful, learning about the history of the Journal of Law and Religion. It's always kind of a shock when I realize that I work with famous professors. But I hope that you can all join our webinar next week and read all of the lovely essays on Canopy Forum. And, if you like to submit an essay for Canopy Forum, you can also email me. But I'll go ahead and put that link in the chat for everyone.
Perfect.
Thank you, Rachel. Well, so this may be a good time for us to bring our event today to a close. I think one of the things that has struck me from the presentations is the conjunction, as Ed emphasized coming out of Jaclyn's presentation, that "and," which is also, I think, a dialectic between particularity and globality, which are themes that were lifted up explicitly by Perry and Jaclyn, that there's a necessary attention to particularity, and that the intersection of law and religion has to be grounded in particularities that then teach us what is possible, but make the work of comparative reflection possible as well. But we can't reside in any one particularity. We are also called to the questions of globality, and those questions change and grow over time as the globe becomes more interconnected. And I think that those themes that Perry and Jaclyn lifted out for us are also themes that were present in Tom and Marie's reflections, that dialectic between particularity and globality has been with the Journal of Law and Religion since its first days and has been reflected in the developments in the journal over these past 40 years. But unlike a Hegelian dialectic, this one doesn't end, right? It just keeps going. The challenges that Jaclyn gives us for the future are challenges that we have to address, and addressing them is the work of a lifetime, the lifetime of any editor or the lifetime of the publication. So residing in the conjunction and residing in that dialectic between particularity and globality is the way that we continue to live out that mission that Wilson and Michael gave us in that very first editorial. Thank you all so much for being with us. Just as a reminder, we will post the recording of this event to the Center for the Study of Law and Religion website, and I'll be sure to share that information with everyone. And we are planning to publish printed versions of these reflections in the first issue of the 40th volume of the journal, which will come out in January of 2025. So please look forward to that. My particular thanks to Rachel Orbetta and Sandra Borden, another of our CSLR student team members who helped make this event possible, to Whitney Barth and John Whitty, the executive and executive and faculty directors of the Center for their support, and to Marianne Babinski, who was on with us briefly, the Dean of Emory Law School, for the law school's continued support of the Center and the journal. And to all of you and all of those who are not with us, the journal is a communion of saints, living and those who have passed on, all of whom have committed immense work to making this enterprise possible. And I am deeply grateful as someone who gets to manage this legacy for the moment, for everything that you all have contributed. And I look forward to seeing all of you again, hopefully in some instantiation soon. Thank you for joining us. Have a wonderful day, night, enjoy some rest. Bye.
Thank you, Silas.
Thank you. Bye.